on South Central today, we find out what does this judgment mean for compassionate appointments, executive powers, and the limits of political promises. Joining us now is Advocate Richardson Wilson to break it all down. Richardson, thank you so much, firstly, for joining us on South Central. Always a pleasure having you on the show. Now, just to go over what the High Court has said, the court essentially said that these appointments, Richardson, violate Articles 14 and 16 of the Indian Constitution. Could you explain for our viewers why the court found the government's decision unconstitutional?
Yeah, thank you, Jude. Always a pleasure being on your show. At the outset, I must tell your viewers that insofar as government employment is concerned, Article 14, which is the Equality Clause, and Article 16, which is the Non-Discrimination Clause, mandates that all selection to government employment be through open competition, right? So the government must issue a selection notification, give wide publicity, advertise it, have an interview or a written test, and then select people on the basis of merit. Now, compassionate appointments are an exception carved out under the law to give appointment to a family member of a government employee who dies in harness. So a policeman, say in the line of duty, he passes away, or somebody from the army, or anybody who dies in harness. So as to ensure that the family has financial stability, there is an exception that you give them compassionate appointments. So the court found that giving compassionate appointments to people who have effectively passed away, no matter how tragically, in a political meeting would set a bad precedent. The other reason that the court has given, of course, I'm on a caveat, Jude, that the court order has not been uploaded, so I have not read it fully. But from the reporting that is in the media and from what I could hear from lawyers who were present in the courtroom, the court has noted that there are already people waiting for compassionate appointments in Tamil Nadu. In fact, Jude, I take this opportunity to mention that in March of this year, the Madurai bench of the High Court had sought a report from the state government on the number of people who are waiting for compassionate appointments. This was in an unrelated case, but the court noted that there are several thousands of people who are waiting. And these are all also family members of government servants who had passed away in harness tragically. So if that is the case, then the government showing undue haste and sort of parachuting the Karur Stampede victims to the top of the line was not justified. And that's what the court has found.
Right. No, it's rather interesting what you mentioned, Richardson, with regard to there being a clear difference between the precedent that has been set before and what is being done now. And you and I both know that governments often announce compensation after major tragedies. So essentially, this court order now draws a line or a fine line between both financial relief and offering public sector jobs. Is that what it ultimately boils down to?
Absolutely, because there is no bar on ex gratia compensation. Once there is a tragedy, the chief minister could announce financial assistance to the family members of those who have passed away tragically in the tragedy. But when it comes to government jobs, Jude, the thinking and the reasoning is, look, there are tens of thousands of youth, and we don't know their tragic circumstances, right? They could be children of single mothers. They could be from the lower economic strata of society. They could have suffered tragedies in their lives. We don't know all of that. So you can't deny them, and they've been waiting in line for 5 years, 10 years, hoping that they'll move up the queue and they'll eventually get a job. So when something like this happens, just because it happened at a TVK rally, and TVK is now the ruling party, they can't, in suppression of all these other youth who have also suffered tragedies, offer compassionate appointments. Nobody is stopping them from giving ex gratia financial assistance, and in fact, they have given. Even when the DMK government was in power, the DMK government announced financial relief, the DMK party announced relief, and the TVK party also announced relief. So that was already given. The issue comes when you give compassionate appointments because you're cutting the queue.
Right. Now, Richardson, does the government have a legal avenue to challenge this verdict? I mean, of course they do. They can challenge it in a higher court. Do you see this likely to happen, though? And is there a way that you can go about doing this in a way that provides relief to these victims' families? But is a challenge likely in this case, Richardson?
I think the media has reported that the state government has already filed an appeal before the Honorable Supreme Court against this order. They may mention for an early hearing as well, but they have made clear their intention to take the order in appeal.
And beyond the politics surrounding Karur, I know for a fact that Karur has been a highly charged political issue since late September last year. What is the broader message that this judgment actually goes about sending in terms of executive discretion, compassionate appointments, and just the procedural sanctity of government recruitment. What do you make of the order in this context?
I think the order, Jude, I must tell you, is one which is absolutely correct in terms of the law behind it, right? And it follows a long line of precedents of judgments of the Supreme Court as well as the Madras High Court, which have consistently held that you cannot have compassionate appointments bypassing those who have been waiting in queue, right? So, because all of these people who are waiting for compassionate appointments have suffered tragedies. So, you cannot bypass that order. In fact, let me give you an example. In 2021, a policeman had passed away in the line of duty in Thoothukudi. Now, his daughter had applied for compassionate appointment and was denied compassionate appointment because the government found that her brother was well to do, in the sense that he had an annual income of 4.5 lakhs. Now, take that as an example, right? You've denied a cop's daughter compassionate appointment because you find that her brother is reasonably well off. 4.5 lakhs is not a lot of money, right? But you found that she's not eligible. So then it begs the question, how can you say that all of these families of the Karur Stampede victim are eligible? Have you gone into their backgrounds? Have you seen if their family members are earning? So the judgment upholds the law that you can't have compassionate appointment in breach of the existing policy. Also, there is a government order, Jude, in Tamil Nadu on how to give compassionate appointments. And without taking a lot of time, let me tell you, they need to go onto a list, right? And compassionate appointments can be given in order of that list. It's like a waiting list.
Absolutely.
And in the Karur case, that procedure was given a go by. So the court has noted that you've acted arbitrarily. And that's why they struck it down. So I think the judgment itself is sound in law. And we have to wait and see what the Honorable Supreme Court does.
Right. Richardson, all I can say is the tragedy of Karur, notwithstanding, this case certainly makes for a fascinating legal study in terms of how compassionate appointments are gone about, being conducted, and whether or not the Tamil Nadu government will pursue this matter in a higher court. But thank you so much for joining us and breaking down some of these insights pertaining to that highly controversial Tamil Nadu government order for 41 government vacancies or government employment to 41 individuals who tragically passed away in Karur. But thank you again for joining us and helping us understand this case.
Thank you for having me on this. Thank you.